Welcome back. I'm Ryan Smith. Casey Anthony's civil attorneys aren't mincing words when it comes to Zenaida Gonzalez's defamation lawsuit against their client. They say that Gonzalez's lawsuit is just a publicity stunt to get her money for damages. Now, they're filing two motions on Casey's behalf. Here they are. The defense's motion for summary judgment and the defense's motion to compel discovery. So let's talk about the defense's side and tell you what all this means. Let's break it down for you so you can understand what's coming in the hearing this afternoon. Joining me now, civil attorney Jeff Shapiro. He is skilled in this area. He is a defamation expert, and he's going to help us sort through some of this. Jeffrey, great to see you.
Thank you.
Now, Jeffrey, let me start.
Happy to be here.
Thanks, Jeffrey. And by the way, I have the defense motion for summary judgment right here. Let me start with one thing they point out just on its face, even before we get to defamation. They say the statements that the plaintiff, on which the plaintiff bases her claims, are protected under the law enforcement investigation privilege, and they start with that point. Now, tell me what that means, and when can someone use statements made to law enforcement in a defamation case?
Okay, well, that's really a very important distinction in this case, because it really goes to the heart of the issue of probably the basis for their motion for summary judgment. Basically, the law wants to encourage people to come forward and speak to the police, make statements about potential suspects, and not fear that they're going to be sued for defamation if it turns out that what they say is incorrect. Florida has spoken directly on that issue and has said, the Supreme Court of Florida has said, that in order for a person to make out a case of defamation against someone who makes a statement to the police, the person must show that the statement made by that person was a malicious intent to injure their reputation. The specific language from the Florida Supreme Court is that the plaintiff in a defamation case against somebody who made a statement to the police must show that that person's primary motive in making the statement was the intent to injure the reputation of the person who's suing. And they go on to say that malice cannot be inferred because the statements were untrue. So that's an extraordinarily high burden for a plaintiff in a defamation case to prove. And it's, very difficult to show that in this particular case where Casey Anthony claims that the person she was describing was somebody completely different, that they would ever get over that threshold.
So let me just make sure I'm clear here. Let's say Casey Anthony went into that police station and said a bunch of statements about Zenaida Gonzalez, and she said them because she just wanted to make up a story. And by the way, before I get into this, let's take a look at those statements that she made to police that are supposed to be the underpinnings of this defamation case. Take a look.
Like on June 9th, 2008, you took Casey to a babysitter's house.
Yes.
And who was this babysitter?
Her name is Zenaida Fernandez Gonzalez.
Do you know how to spell the first name?
Z-E-N-A-I-D-A.
How long had you known Zenaida?
Almost 4 years. It'll be 4 years Christmas this year.
And where did you meet her? Who did you meet her through?
A mutual friend. His name is Jeffrey Michael Hopkins. I met him at Nickelodeon at Universal, and I met her through him. She was his son's nanny at the time.
And when did she start watching over your child?
It's been within the last year and a half, 2 years that she started watching Kaylee. I had another friend watch Kaylee that I've known since middle school. When she went back to school, I was looking for a new nanny. Jeff offered to have Zenaida watch both kids. She agreed, and it kind of went from there.
You said Zenaida had family up in New England, up in New York, or
yes,
something?
Yes, she has family down south. Her mother, her sister, her brother's in New York. She's originally from New York.
And where's down south?
Miami area.
Where's she originally from?
New York.
She born and raised in New York? She have family outside of the country, or?
I don't know. As far as I know, she pretty much grew up there, moved down here, went to the University of Florida.
Is she Puerto Rican? Is she Dominican? Is she white?
She's mixed. She's black and Puerto Rican.
And you don't know what her birthday is, or you don't know what her birthday is?
It's in September. That's all I can remember at the moment.
So, Jeffrey, let me make sure I have this straight. Even if she's making these statements, even if she's talking about the exact same person, the only way these statements can be used in defamation cases like this is if she did it for the express purpose to try to hurt Zenaida Fernandez Gonzalez, not to maybe avoid prosecution or something of that nature?
Well, that's the Florida law. That's the statement made by the Florida Supreme Court. But keep in mind, that even though it is such a high standard, that doesn't mean that the plaintiff in a defamation case wouldn't be given the opportunity to try to prove that at trial. You know, the issue that's really before the court today isn't whether this reaches that standard or not. Rather, it's whether or not this case should go to trial.
All right.
So, you know, I think the plaintiff is going to take the position, well, let me ask you something here, Judge. If a person who's accused of committing a murder she's laying that off on my client, how is that anything but a malicious effort to injure the reputation of my client? How could it be anything but that? She's accusing my client, essentially, of murdering her daughter. Okay. So if that doesn't meet the standard, what does?
That's interesting. Now let's assume these statements can be used in the defamation case. Let's assume that immunity doesn't apply. Talk to us about what the plaintiff would need to prove, just in basic, simple terms. Talk to us about what the plaintiff would need to prove in order to prove defamation against Casey Anthony.
She would have to prove three things. First, that false statements were made about her. Okay? Actually, that's the most important part, that false statements were made about her. Number two, that these statements were published in some way. That's the legal term, published, meaning that this information was disseminated to people other than to the police. And number three, that she was damaged in some way by the publishing of these false, malicious statements. Those are the three things she has to prove here.
All right, now let's talk about Zenaida Gonzalez as well. I spoke to her last year, and she was trying to figure out why Casey Anthony targeted her. Here was her thought on that.
How do you think Casey Anthony got your name and your information? How do you think a lot of people are saying she created a Zenaida Gonzalez, but how did she connect to you, do you think?
What my personal thought would be from Sawgrass Apartments. I mean, that's the only place that had my car, my daughter's names, my name, you know, my information, my personal information. You know, nobody else had it. I mean, I don't understand how else she can get to it. You just cannot imagine the same car, the two girls' names, which is the same name, my name perfectly written, perfectly, you know, when they asked her to spell it out, she spelled it out perfectly. And that's kind of strange for an American person to spell my name the right way. They never do get it right.
Now, there's an interesting facet to this, Jeffrey, in that the name that Casey Anthony used was Zenaida Fernandez Gonzalez. That woman's name is Zenaida Gonzalez. So let's say Casey Anthony somehow saw this application, whatever it was, got that name, and then started crafting a story that the description of the two people isn't the same, the circumstances aren't necessarily the same, but saw that, and that's how she came up with the story. Is that then a winnable defamation case for the plaintiff?
It would be very difficult to win that case, but you know, the thing would be, would it be dismissed on summary judgment? Mm-hmm. Probably not. Probably the judge would let a case like that go to a jury and let a jury decide what to do with it. But you know, the problem the plaintiff has here is that Casey Anthony just didn't give the police a name. She gave them a name along with a lot of other descriptive information, including, you know, how old she was, how she met her. In fact, it claimed to have known this person for a number of years, none of which fits this plaintiff. And the other sort of red herring in this case is as you know, when Ms. Gonzalez started her lawsuit, she started in the name of Zenaida Fernandez Gonzalez, which is not her name, and then subsequently, a number of months later, served an amended complaint where she now is just Zenaida Gonzalez. And the defense has made a big point of that because they've said, you know, this woman knew she wasn't the right person. She knew she wasn't the one that Casey Anthony was talking about, used a false name in the first complaint that she filed, so she would try to sort of shoehorn herself into this as a case. And the other sort of interesting thing here, which I'm sure the defense is going to make a big point of today, is that although in the caption of the first complaint, she claimed to be Zenaida Fernandez Gonzalez, in the retainer that she signed with her lawyers, she was Zenaida Gonzalez.
Yeah, so it's almost as if they saw it later.
The defense has a lot to talk about today.
Yeah, it's almost as if they saw it later and said, oh, let's make sure that's clear. Hey, one more thing here.
Exactly.
As we look at this case, and we talk about the names being different, and I want to show our viewers this as well, the differences between the two descriptions. One is Casey Anthony's thought on who Zenaida Gonzalez is, and the other one is who Zenaida Gonzalez actually is, if we can put that up on screen. You know, and you see the differences. This is Zenaida Fernandez Gonzalez. Those are her descriptions as given by Casey Anthony. 25 years old, 5'7", dark hair, no children. And according to the court documents, the plaintiff is actually 38 years old at the time Kaylee disappeared. Now, Zenaida Gonzalez, the actual one, is the one here in this case, is much shorter, 5'2", light brown hair, children. Let me ask you this. As you look at those description differences, how big does that play out in this particular case? Not necessarily for the summary judgment motion, but actually in the case if it does make it to trial.
You know, I think it comes down to this. It sounds as if, it makes it sound that what Casey Anthony was saying to the police was a complete fabrication. It's a name that she picked out of thin air. The story about how she met the person is untrue. The description of the person is untrue. Basically, she's describing a fictional character who just simply, who coincidentally happens to have at least two parts of the same name of the person who's suing her for defamation. So, you know, I think it'd be pretty tough under those circumstances when you look at it, no matter what you might think of Casey Anthony, no matter how poorly you might think of her to be fabricating a story out of thin air for the police. The fact of the matter is, who is she defaming? She's defaming some person that really doesn't exist.
But here's the thing, and let me ask you this. Ryan Smith is a fabrication. That's an easy name to make up. Zenaida Fernandez Gonzalez is not an easy name to make up. And we saw in the statement that was actually just played from police that she is capable of lying about things. We know that from the court case. How can we know that she's not lying about Zenaida, trying to target Zenaida Gonzalez?
Well, you know, look, I represent plaintiffs in these cases, so I mean, I have to tell you, that's my bias. The problem is the plaintiff's name in this case isn't Zenaida Fernandez Gonzalez. It's Zenaida Gonzalez. So, you know, that's sort of a big problem, which was recognized, I think, by her own lawyers. First of all, they didn't even have her sign the retainer in that name. They had her sign the retainer in her real name. You know, so they knew on day one that this was a different name than Casey Anthony was describing.
All right, let me bring in Sonny Hostin as well, talk about this a little bit. Hey, Sonny, it's not just about the motion to dismiss today. The plaintiff is also trying to bring in some of the video diary information. You think they have a chance of getting that information? These, of course, are the video diaries that Casey Anthony has created since she's been acquitted of many of those charges.
Yeah, I'm not sure. I would imagine that perhaps a judge would want to listen to them in camera, look at them in camera to determine whether or not it's relevant, to determine whether or not to turn it over. So I'm not sure about that. But I think it's something that certainly a judge will want to look at. We already know this judge has determined that some things are just irrelevant, and that, you know, she may not need to answer many questions. But in terms of the video diaries, I just wouldn't be surprised if a judge would at least want to take a look at it to make sure that there isn't anything relevant that should be turned over to the other side.
All right, and Jeffrey, let's talk about the summary judgment motion in general. Do you think the defense's motion for summary judgment passes here, is accepted by the judge, or you think it has very little chance of succeeding?
Well, look, here are the rules that apply to a summary judgment motion. Basically, when a judge is looking at a motion like this, he or she is trying to determine, is there any way that this case, assuming that it was tried and assuming the plaintiff won, would that verdict be sustained? And if so, then the judge basically has to deny the motion. But if the judge looks at this and says, look, even if the plaintiff proves everything they say they're going to prove, would that be sufficient? And a jury believed it and gave a verdict to the plaintiff, would I have to throw the case out there anyway? And in this case, I think it's a really close call. I think it's a very close call. And, you know, the Florida Supreme Court, no less than an authority of that, has spoken that these is a very rigorous standard for a plaintiff to establish in order to prove a case for someone who makes allegedly defamatory comments to a law enforcement officer. The judge could decide to throw out the case on simply that grounds and figure that, you know what, worst case scenario, let the Florida Supreme Court tell me I'm wrong. And I think that he'd probably have, or she would have a probable basis to do that. And I don't think that he would be worried too much about criticism for that decision.
All right, Jeffrey, Sonny, thank you.